great pleasure to have Bruce Frier here for the last of the Laws Two Bodies sessions for the year. Bruce works at the University of Michigan, initially in classics, then both in classics and in law, and now in law alone.
That's right.
He's probably, his book most relevant to today's talk is probably a work called The Rise of the Roman Jurists, which is well worth you reading, even if you don't think you're interested in the birth of the Roman jurists. It's a book of extreme interest and considerable readability, which means I read it for fun.
Good job.
I did indeed. Today, though, he is going to be talking to us about the views of a Roman jurist, and so we will begin. Bruce, thank you very much for being here. Can you tell us a bit about the jurist who you are going to be telling us about today?
I'm not going to be acting. I'm going to be trying to answer from the viewpoint of Julian, who is one of the great Roman jurists. He dates mostly from about the second quarter of the 2nd century CE. He comes at the end of a very long chain of events, some of which we'll have to discuss. But he was apparently a new man in the sense that his family had no previous office at Rome. He comes into prominence on the basis of his legal talent and follows a career through the Roman Senate. A fairly typical career for a member of the upper classes that come in addition to the Republican offices that he holds of quaestor, praetor, consul, also involves governorships and so on. Quite considerable administrative experience. We know that he lived into the reign of Marcus Aurelius, and by then he was preeminent among the jurists in Rome. He also is, to some extent, at the end of an important period in Roman law when the jurists were mainly concentrated in the Roman Senate, and I'll be talking a little more about that actually tomorrow. His reputation is as high as any Roman jurist. Probably the only clear rival he has is someone from 2 generations later, Papinian, but he is regarded as, he's described by Justinian as a subtilissimus, an exceedingly subtle interpreter of the laws and of the perpetual edict. Under the reign of Hadrian, he was asked to prepare the final edition of the Praetor's Edict, which was the essential procedural document. He did so, making some important innovations, but basically bringing the history of the edict, the long, long history of the Praetor's Edict, to a close. It was thereafter fixed in its form, and accordingly, the later Roman jurists turned to its interpretation rather than to suggesting innovations in the edict. I wanted to emphasize actually the breadth of his experience. He, in addition to his offices at Rome and his priesthood, he was a pontifex. He also was a legate in Lower Germany, which is the part of the Rhine Valley that is today the Netherlands, and Belgium, and then also in Spain, and he was a proconsul in Africa. So he had very wide experience of the Roman Empire, although he never, insofar as we know, went outside of its boundaries into the barbarian territory north of Hadrian's Wall.
So you've talked about the variety of his career, his appointments. So what sort of amount of his working time would have been devoted to matters that he'd consider matters of law?
That's a difficult question to answer. He wrote prodigiously. The digests, his digests are 90 books in length. These, of course, are Roman books, so they're shorter than our books. but they include not only a commentary, detailed commentary on the Praetor's Edict, but also commentary on the major laws that affected private law in one way or another. He commented on some earlier jurists as well, and wrote a book on the ambiguities of law, which is actually not about the problem of ambiguity in law as in the abstract, but about particular sets of issues that arose because of the uncertainty of law. But we don't, with Justinian as with most of the jurists, we don't know very much about his daily life, like what I would say. So one has to assume that a great deal of his time that wasn't taken up with official duties did involve the law in one way or another, but it could have involved things other than writing. It could very easily have involved things other than writing. For instance, speaking with litigants, advising magistrates, and so on. Quite likely did, if we can judge from the experience of other jurists. If he had any views on the world around him, that is to say, the time of the good emperors in the 2nd century, he kept those to himself.
And how would he have learnt about law? Not so much in terms of when he's producing legal scholarship, but in terms of legal education or legal formation.
The date of his birth is not entirely certain. It's usually put at about 100 CE. We know from his own testimony that he was a student of Javolenus, who's one of the great jurists of the early high classical period. And that was probably typical of most jurists. We don't know exactly what legal education would have looked like, except that there were no law schools at the time.
So when you say he's a student of,
he probably went and lived with him and followed him around and learned the law from him, but exactly how that worked is not clear. And in fact, it was one of the really great mysteries about Roman law. It's important, a lot of emphasis is laid in our sources on this teacher-student relationship, and it's fairly crucial to the transmission of law from one generation to another, but the legal education system looks extremely rudimentary. The other side of it is that there's nothing by way of professional qualification involved. The jurists like Julian become prominent simply on the basis of their ability, their peer recognition amongst older jurists, their ability to transmit opinions that the world accepts as good. That situation is going to change in the middle of the century. But in Julian's time, it was still very rudimentary.
And what in opinions establishes your standing? What qualities are looked for?
Well, we have a sort of, we owe a great deal actually to what is recorded as an anecdote, but this is, actually I'll be showing you this tomorrow, but a number of people who regarded themselves as learned in the law approached Hadrian about being declared official spokespersons for the law with the authority of the emperor. And Hadrian said that was something that was customarily awarded and not asked for. If you wanted to be recognized as a jurist, Hadrian would be very happy, he says, if you went out and prepared yourself for the law. I think that although it's given as a sort of example of Hadrian's sour wit, it probably is pretty close to the reality even at that date. So we're talking about a handful of people. It really is important to recognize this. I mean, this juristic community in Rome at any one time is certain to have involved fewer people than are in this room. And it really is important to understand how small this community was. By Julian's time, though, it was beginning to develop an underclass of of less qualified jurists, not necessarily located in Rome, out in the provinces, and also gradually through, again, this rudimentary process of education, legally educated folks, bureaucrats, notaries. Notaries were probably the earliest of these legally educated people, not of the juristic class.
So the group of jurists are educated and communicate with each other in ways which are primarily oral?
No, primarily written, I think.
Primarily.
We have no particular evidence, no evidence of any kind, really, of their having gotten together and argued questions out. It's not impossible that it occurred, but we're to some extent just hamstrung by the nature of our sources, which all stem from the writings that they did and were then sort of channeled through the digest of Justinian at tremendous costs of compression.
But is your sense of it that it's a competitive community?
It turns out to be more complicated than that, and let me just put that question off for tomorrow. It's an interesting question, and it hasn't been much examined in the literature. It's competitive in a way, clearly. We know that Julian didn't like his great rival Celsus, but he never mentioned Celsus by name. We just know it from opinions of his that challenged Celsus without mentioning him. So it's a sort of, it's clear that there's tension, but the tension is very carefully circumscribed in this community, and I'll try to explain why that might be so. Go ahead.
And in terms of the jurist's opinion forming some sort of body of knowledge, and that it survives primarily, and may have existed primarily in written form, what in a sense is the legal standing of that body of knowledge?
That's a question that really does take one back quite a bit into the history of Roman law. I think largely as a result of John Crook's writing, late John Crook's writing, it has become clear, perhaps not to all Romanists, but at least to me, that the early Roman Empire had two legal professions simultaneously, so that your two bodies in Rome, if we think of them as theorists and practitioners, they were actually quite separate from one another in the early empire. The practitioners were represented by the rhetoricians who had dominated the court system of Rome since the 2nd century BCE, it was inherent in the dynamics of rhetoric that they were very reluctant to recognize any external authority, except for the authority of statute. But their approach is highly case-oriented. If I'm speaking now in the guise of Julian, I can imagine him absolutely detesting the younger Pliny, who would represent for him just exactly what was wrong with the rhetorical tradition. Their attitude towards law towards the law that the jurists were propounding tended to be, if it's on our side, we're stoutly in favor of the jurist, and if it isn't, we will argue against it. And they developed techniques. Rhetoric consists almost entirely of techniques for arguing either side of a question, and they developed techniques for declaring that the juristic opinions that were put up against them simply didn't apply to this case, or were wrongly decided, or any of a variety of reasons. That makes the question of the relationship between the jurists and the courts a difficult one. The evidence we have suggests that the jurists were extremely interested in the courts, that they followed what went on in the courts, It's my belief, and I think pretty generally held nowadays, that the jurists were influenced by the rhetorical arguments that they heard, in the sense that those arguments often, in a sophisticated form, represented interests that were in play in legal questions. But it's very rare we have the opportunity to see that in practice. Because well, we know very little about the dockets, for instance, of courts. We know little about the actual argument that was being conducted after the death of Cicero. Cicero published a number of his private orations, but thereafter we don't know very much about what they looked like, apart from some reason authors like Pliny the Younger. I some years ago wrote about one of the examples where we do, as it seems, know something about the history. This involved the invention by Celsus of the rule with regard to bees, ownership of bees that fly away from the hive, and he invents the rule called animus revertendi, that so long as the animal has the intent to return, it is regarded as still the property of the beekeeper. And it just so happens that in the corpus of Pseudo Quintilian, probably early 2nd century, we have a rhetorical exercise that argues this very point. And in the rhetorical exercise, you get none of the legal gymnastics that Celsus was engaged in. You get the straight-out representation of defending the beekeeper, essentially, presented in a usual rhetorical format of, this is a poor man whose bees have been poisoned by his rich neighbor, and so on. Pretty turgid stuff, but if this represents anything that went on in actual practice, you can begin to see influences flowing from the courtroom into decisions. It's a fairly important point, this, because it used to be thought that Roman law proceeded almost without regard to the world around it, as a kind of abstract exercise. And that had always struck me as very improbable because of the extraordinary influence of Roman law. I mean, if it had been just a pure thought game, it's hard to imagine it having the degree of influence that it subsequently had. But it's hard to get the details of it.
What we normally ask, and you've 3/4 answered, is whether there would be interest in other legal systems. It sounds to me as if you're suggesting that he wouldn't be interested in other legal systems, but he's interested in the business of the courts and possibly the behaviour of the courts, rather than there being a separate body of law of the courts.
I think that's true. We do have the writings of the jurist Gaius in the next generation from Julian, who clearly is interested in other legal systems within the empire, at any rate. But the Roman jurists have very little interest per se in other systems, and this is conditioned, at least in part, on their worldview, which is that the Roman Empire is the world, and accordingly, if at an early date in Roman law, and here the details are extremely obscure, but if at an early date in Roman law, during the Roman Republic, the law had been open to a certain extent by taking consideration of the world of other than the Roman Empire, through the jus gentium, the way people in general do things. By the Roman Empire, the jus gentium has been pretty largely merged with natural law. It no longer has an independent force. They don't have much interest in other legal systems. And if your next question were going to be, are they interested in the history of law? No, they're not much interested in that either. And again, Gaius is an exception. But they don't really do much with the history of law, even the history of their own law.
And you would think that it is a personal difference in Gaius rather than the form of text that survives from him?
Remains a debatable question. Gaius is a difficult figure, particularly since his Institutes is the only work of classical jurisprudence that survives relatively intact. And sort of saying that he's special and outside of the juristic mainstream may be a little unfair, but he is never cited by any other jurist. And he seems to have been out of the mainstream at the city of Rome. Whether he was actually teaching in a provincial capital like Beirut that's possible. Beirut already had a law school by about 200 at least, and Gaius has been placed there, but it really is very difficult to say. But he is interested in early law and writes about it, even in the Institutes. Most of the jurists seem utterly indifferent to institutions that were dead in their time. Now, it needs to be said, we're competing against the narrative of Roman law that's set up by the Digest of Justinian, and Justinian himself had very little interest in legal history, so he could systematically have edited out all of those details. But I think not. I think that the way that the jurists go about arguing suggests that they don't draw arguments from history, for instance.
You talk about one of his works being known as the ambiguities of law, and suggested it might be better described as legal ambiguities or ambiguities in laws or something like that.
Problems that raise ambiguities.
How far is he interested in abstract ideas of law, abstract aspects of law, or is this again hard to say?
It's a fascinating question. I remember having sat through a conference at Princeton on Islamic law. This was in the days after the Iranian Revolution, but before the Gulf War, so it was a sort of happy interval. There were sharply competing schools, strongly influenced. The dialogue was strongly influenced by Aristotle. None of that in Roman law. Insofar as we know, Roman law seems really unique in that we have no evidence that any Roman jurist ever wrote a work on sort of the methodology of law itself. They seem almost deliberately disinterested in the topic. They do say things from time to time that indicate that they're not unaware of the issues that are involved. And Justinian's compilers went through their works systematically pulling these together from diverse sections, what are often just little snippets on which later ages have erected great edifices of thinking. But the jurists themselves, it's almost casual the way they deal with legal philosophy, with questions of morality, and they don't seem to want to go down that route. And accordingly, as I am prone to put it from time to time, the Digest of Justinian looks like a sort of great monument to the virtues of thinking inside the box. It's just surprising to see a body of law that grows up so deliberately within the schema of the Edict of the Urban Praetor, develops that schema in elaborate and extremely interesting ways and important ways, but never really wants to radically depart from it. There's a kind of caution there that seems to be built into their system, and that is, frankly, rather difficult to explain.
When it was Justinian who referred to him as subtilissimus.
Yes.
Is that a compliment?
I think so, yes.
Yeah. In medieval terms, it wouldn't necessarily be.
I see. Well, he's. I don't think it means that he's scholastic.
Yeah.
That's what you're saying.
And then the last thing we ask seems slightly detached, but in many ways is connected to a lot of the things that you're saying, is how far would he see law as a way of controlling emotion or excluding emotion from dispute, but not just from dispute, but also from personal decision?
Well, I don't know. I saw the question. I read the question when you sent it to me, and it's hard to answer. A lot of the jurisprudence of the Romans seems fairly mechanical. The tendency in the scholarship over the last 200 years has been initially to take that coldness, that way of thinking, as in fact the way the jurists were. The famous expression that Carl von Savigny used to refer to them was as fungible personalities. I mean, they don't have any outstanding characteristics. That view has been largely overcome, but one is left with a sense that unlike the jurists in practically any other age, there's not much effort to express personality in the law. So they don't become excited, except very occasionally. As I'll be discussing tomorrow, they don't engage in personal argument with one another. There is little in the way of direct emotion, despite the fact that we know that they often disagreed with one another.
Could this be in deliberate opposition to the rhetoricians, whose job very largely is to manipulate?
I think it's almost overpowering to make that assumption, yes, that they adopt a mode of argument that distinguishes them very clearly from rhetoric. As a strategy, perhaps, to promoting their own product, but it's during the late Republic, there's sense of actual hostility between the jurists and the advocates like Cicero. That tends to vanish. I mean, they and very, very gradually during the first century and a half of the empire, the jurists appear to be getting the upper hand, but it's very hard to measure without knowing more about how the courts are operating. John Crook did a detailed study, which is actually now being extended into the trial records that survive from Egypt, which had not really been looked at closely before, but they show admittedly it's Egypt, it's not an unusual province, but they show a gradually increasing tendency towards rule-based decision-making. And that is something that the jurists would clearly have approved of. That is getting away from a case-based approach to justice. The subject I am actually more interested in, and it's not utterly unrelated to the problem of emotion, is and has been almost not studied at all, and there are not enough years left in my life to study it, but is the process whereby, leaving aside issues of the influence of the economy and of social expectations on the law and the ability of law to control society, the process whereby legal values that are essentially just associated with the law, like due process and equal protection and good faith and so on, gradually made their way out of the law and into social discourse. I see some evidence for that in the Roman legal sources, a tendency to, for instance, to take charge of situations that have the potential for violence, like landlords seizing the property of their tenants for non-payment of rent, and involving imperial authorities in that. But it's tricky, and it takes a lot of subtlety to tease that out of our sources.